Friends, thank you for being here today. We find ourselves at a moment in our nation's history that demands not just our attention, but our deepest understanding. What if I told you that the very foundation of our judicial system, the simple, sacred idea that a court order is a command, not a suggestion, was tested to its breaking point this week? And can we honestly say that our democracy is secure if the most powerful among us are permitted to shatter the rules that bind the rest of us? These are not hypothetical questions posed in a law school classroom. They are the urgent realities facing us right now. We are gathered here to unpack a legal earthquake that occurred in a federal courtroom just days ago, an event so significant that it sent shockwaves through Washington, D.C., and across the country. We are talking about the moment a federal judge, a figure of restrained authority, finally said enough. For months, we have watched a slow-motion collision between the irresistible force of Donald Trump, AIM-S political strategy, and the immovable object of the federal legal system. We have seen fines levied. We have seen gag orders issued, appealed, modified, and violated. We have seen a former president test the boundaries of what is permissible in a court of law, treating legal restrictions with the same combative energy he brings to the campaign trail. But what happened on December 12th was different. It was not a procedural skirmish. It was not a debate over scheduling or the admissibility of evidence. It was a confrontation over the most fundamental power a judge possesses, the power to enforce their own orders. In this extensive analysis, we are going to walk through exactly what happened, step by step. We will look at the specific red-handed violation that caused a judge to erupt in a way rarely seen from the bench. We will examine the nuclear option that is now on the table, the genuine threat of jail time for a former president. And perhaps, most importantly, we will discuss what this means for the future of the rule of law in America. Because when the dust settles, this story isn't just about one man or one judge. It is about whether the system itself can hold. To truly understand the magnitude of this event, we must first transport ourselves directly into the heat of that federal courtroom. Federal courts are typically places of quiet dignity. They are controlled environments where passions are tempered by procedure, where attorneys speak in measured tones, and where judges rule with a stoic, almost detached demeanor. It is rare for a federal judge to raise their voice. It is rarer still for them to express visible anger. But on this day, the atmosphere was electric with tension. According to multiple reporters present in the room, the judge unleashed one of the most blistering courtroom tirades in modern legal history. This was not a lecture. It was a dressing down. The judge's voice reportedly rose to a level that startled the seasoned legal journalists and attorneys in attendance. She used words that carry immense weight in the legal profession. Words like flagrant disregard and contempt for this court's authority. Why such a reaction? Because Donald Trump wasn't just caught bending the rules. He wasn't operating in a gray area where a clever lawyer could argue interpretation. He was caught doing the exact thing the judge had explicitly, in writing, forbade him from doing. The evidence was not circumstantial. It was undeniable. Imagine for a moment you are a parent who has told a child not to touch a hot stove. You have written it down. You have made them sign a paper saying they understand. And then, right in front of you, they place their hand on the burner and look you in the eye. That is the level of defiance the court was dealing with. But this is not a household dispute. It is a federal criminal proceeding involving national security secrets. The judge characterized the defendant's behavior as an affront to the justice system itself. This is profound language. She wasn't saying he annoyed her personally. She was saying his actions attacked the institution of justice. Trump, for his part, sat at the defense table, reportedly visibly fuming. This wasn't a standard legal setback where a motion is denied. This was a sitting federal judge looking a former president in the eye and declaring that he had shown deliberate defiance. When federal judges start using language like deliberate defiance and affront to justice, you know something massive has shifted. The veneer of deference usually afforded to a former commander-in-chief had evaporated. In its place was the raw power of the judicial branch asserting its supremacy over the proceedings. But to fully appreciate why this explosion occurred, we have to look back at the months of high-stakes tension that led us to this moment. This judge has been in an incredibly difficult position. Pointed to the federal bench with bipartisan support back in 2019, she has been walking a tightrope since the day this case was assigned to her. On one side of the tightrope is the need to treat Donald Trump like any other defendant. The blindfold on Lady Justice implies that wealth, power, and fame should not tip the scales. On the other side is the undeniable reality that he is a former president and the current frontrunner for the Republican nomination. This unique status creates logistical and political nightmares that no judge has ever had to navigate before. For months, the judge tried to balance these competing realities. She granted courtesies. She allowed for scheduling flexibility. She endured attacks on her own impartiality without responding in kind. She was trying, essentially, to keep the temperature down and ensure the process appeared fair to all observers. Early in the case, she issued a protective order, Now, protective orders are standard in cases involving classified documents or sensitive witnesses. Their purpose is simple: to ensure that the evidence shared with the defense team during the discovery phase is not leaked to the public. This is crucial for two reasons. First, to protect national security. Second, to ensure that witnesses, people who are doing their civic duty by testifying, are not harassed, threatened, or intimidated. According to a Politico report from December 8th, the protective order in this case was crystal clear. It wasn't full of legalese or ambiguous clauses. It laid out in explicit terms what Trump could and could not say publicly. It specifically prohibited the public discussion of certain evidence, the naming of witnesses, or the revelation of details that could taint the jury pool. Most importantly, Trump's attorneys signed off on this order. They acknowledged they understood the restrictions. They communicated these restrictions to their client. For weeks, Trump mostly complied. He pushed right up against the boundaries, posting on Truth Social about the witch hunt and the corrupt system, but he generally skirted the edge of what was legally permissible regarding the specific evidence. But then came December 10th. On that day, the rubber met the road. Trump posted a series of messages that didn't just approach the line, they obliterated it. According to CNN's legal team, Trump named a confidential witness. He didn't use a pseudonym. He didn't use a vague description. He named them. Furthermore, he shared details about classified evidence that was currently under seal. Let's pause and be real for a second. If you or I did this, if a regular defendant in a drug case or a fraud case went onto social media and named the confidential informant testifying against them, we would be in jail before the sun went down. Violating a court order regarding witness safety is one of the quickest ways to lose your freedom while awaiting trial. Judges take it extremely seriously because if defendants can ignore court orders, the entire system breaks down. It becomes the Wild West. All of this context brings us to the pivotal hearing on December 12th, where the simmering tension finally boiled over. According to multiple sources inside the courtroom, including reporters from CBS News, the proceedings started relatively calmly. It began as many hearings do, with the prosecutors presenting their motion. The prosecution's case was simple and devastating. They didn't need complicated legal theories. They presented screenshots. They had the Truth Social posts, preserved and time-stamped, showing exactly when they were made. They contrasted these posts with the text of the protective order. Trump's attorneys, caught in an impossible position, attempted to do what defense lawyers do. They tried to spin. They argued that the posts were a general commentary about the case. They argued that Trump wasn't targeting the witness, but rather commenting on the nature of the investigation. They raised the banner of the First Amendment, arguing that, as a candidate for president, Trump had a right to defend himself publicly. The judge listened. She asked clarifying questions. She seemed to be methodically working through the arguments, giving the defense their due process. Then came the moment that changed everything. According to NBC News reporters who witnessed it, the judge stopped the back and forth. She pulled up the actual protective order on the large courtroom screens. She then began reading it aloud, line by line. She would read a line from her order. The defendant shall not disclose the identity of witnesses. Then she would point to Trump's post, where he named the individual by their full name. She read another line. The defendant shall not discuss classified materials under seal. Then she pointed to Trump's post, describing specific documents. It was a visual dismantling of the defense's argument. The language was unmistakable. It was so blatant, so undeniable, that the courtroom fell completely silent. You could hear a pin drop. The general commentary defense evaporated instantly under the harsh light of the facts. When Trump's lead attorney reportedly tried to interject, to offer some explanation or mitigation, the judge raised her hand and silenced him. She wasn't finished. Turning directly to Donald Trump, she delivered the rebuke that will be quoted in history books. "Mr. Trump," she said, "do you understand that when this court issues an order, it is not a suggestion? It is not a guideline for your attorneys to interpret creatively. It is a binding legal directive that you are required to follow." Reporters noted that her voice had an edge to it that hadn't been there before. Your posts from December 10th represent a flagrant and intentional violation of this court's protective order. The evidence is not ambiguous. The violation is not debatable. You did exactly what this court explicitly forbade you from doing. Trump, according to observers, sat forward in his chair, his face reddened. His attorneys were frantically passing him notes, clearly trying to keep him from reacting, from shouting out, from making the situation exponentially worse. They knew, even if he didn't, that they were standing on the precipice of disaster. After establishing the undeniable nature of the violation, the judge moved swiftly to address the consequences. She stated she was holding Donald Trump in contempt of court. First came the financial sanctions. She fined him $50,000 for each violation. The judge knew this. She knew that fines alone had not stopped Trump in the past. And this is where she dropped the bombshell. The judge stated clearly that if Trump violated the protective order again, she would not hesitate to impose custodial sanctions. In legal terms, custodial sanctions is a polite way of saying jail time. According to legal experts watching the proceedings, this was the nuclear option. A federal judge was putting a former president on notice that he could be taken into custody. She explained her rationale. She said she had given Trump every benefit of the doubt. She had crafted the protective order with his unique position as a candidate in mind. She had been patient with his boundary-testing behavior up until now, but she noted this clear violation left her no choice. She had to impose meaningful sanctions to protect the integrity of the proceedings. This testimony sent shockwaves through the courtroom. It wasn't just about fines or procedural slaps on the wrist. This was a federal judge essentially saying that Trump's conduct was so egregious, so contemptuous of judicial authority, that incarceration was now on the table. This is a profound shift. Until this moment, the idea of jailing Trump for contempt felt like a theoretical possibility, something pundits discussed on cable news, but that no judge would actually dare to do. The Secret Service logistics alone make it a nightmare. The political fallout would be catastrophic. But this judge looked at the facts and decided that the risk to the rule of law was greater than the risk of political fallout. I want to pause here and ask you directly, do you think the judge was right to finally put jail time on the table? Or do you believe this crosses a line? This is a moment that divides legal experts, and I want to know where you stand. Scroll down right now and leave a comment with your thoughts. Is this justice, or is it overreach? Now, to understand why the judge reached this absolute breaking point, we have to look at the long history of defiance that paved the way. This isn't the first time we've seen Trump clash with judges over what he can say. Recall Judge Juan Merchan during the New York trial regarding the hush money payments. Trump posted about the judge's daughter. He made claims about bias. He violated gag orders so many times that the court held him in contempt multiple times. He paid thousands in fines, but he kept pushing. He seemed convinced that judges wouldn't actually jail him no matter what he did. And in that case, he was right. He faced financial penalties, but he never faced the threat of custody that would have silenced any other defendant immediately. Then there was Judge Tanya Chutkan in the January 6th case in D.C. She issued a gag order after Trump attacked prosecutors and potential witnesses on social media. Trump's attorneys fought that order all the way up through appeals. While they got some modifications, the core restrictions remained. Trump violated those restrictions too. The judge held hearings, imposed additional penalties, but again the cycle continued. And let's not forget Judge Arthur Engoron in the New York civil fraud trial. He fined Trump repeatedly for attacks on court staff, specifically the judge's law clerk. Trump posted a photo of her on social media with false claims about her political affiliations. This led to immediate sanctions and a strict gag order. Even after being fined, Trump made comments that came close to violating the order again. Even Judge Aileen Cannon, who oversees the classified documents case in Florida and has been viewed by many legal analysts as sympathetic to Trump, has had to issue warnings about improper public statements. Across all these cases, the pattern has been identical. Trump pushes boundaries, he gets warned, he pays fines, he keeps doing it. Why? Because the ultimate sanction, jail time, has never actually been imposed. He has successfully called the legal system's bluff time and time again. This strategy relies on a simple calculation. I am too big to jail. He gambles that his status as a former president and a current candidate creates a force field around him. He gambles that judges will be too afraid of appearing political or too worried about the logistical nightmare to enforce their orders with the only tool that actually works. But now it looks like that strategy has finally met a wall. This judge signaled that the calculation has changed. She signaled that the judicial system may no longer accept fines as a sufficient deterrent for a wealthy defendant who treats them as a marketing expense. So we must ask ourselves, why does this specific ruling matter so much more than the headlines we see every day? Why is it more than just another headline in the endless cycle of Trump legal news? First and foremost, it is about witness safety and obstruction of justice. The judge explicitly noted that the witness Trump named had already received threats after being publicly identified in court filings. Trump knew this. By amplifying that identification on his social media platform to millions of followers, he wasn't just venting, he was putting a target on a citizen's back. The judge used the phrase reckless disregard for the individual's safety. Legal experts told CNN that this language transforms the violation from a technical infraction into something far more serious. It's not just about Trump's First Amendment rights versus court authority. It is about whether the justice system can protect the people who participate in it. If witnesses are too terrified to testify because they know the defendant can expose them to millions of angry followers without consequence, then the trial cannot function. Justice cannot be done. This puts Trump's legal team in an extraordinarily difficult position. On one side, they need to control their client. Every attorney who has represented Trump has faced this challenge. How do you defend someone who actively sabotages his own defense? How do you mount a legal strategy when your client keeps creating new evidence of obstruction? On the other side, they have to somehow argue to appellate courts that the contempt finding and sanctions were too harsh. But that is extraordinarily difficult when the violations are so clear. Trump's posts are time-stamped, they are archived, they are impossible to deny. The protective order language was explicit, there is no ambiguity for appeals, courts to seize on, no gray area that might suggest the judge overreached. This ruling also has immediate political implications. It undermines the victim narrative. Trump's story has always been that he is being persecuted by a rigged system, that the judges are biased, that the cases are political witch hunts. But when you're caught violating an explicit order, like naming a witness you promised not to name, and a judge has to threaten you with jail, that narrative becomes much harder to sell to anyone outside the most committed base. Moderate voters, independents, and even some traditional Republicans who were giving Trump the benefit of the doubt now see documented proof that he deliberately defied a court order. It isn't the deep state attacking him, it is a judge enforcing a rule he agreed to follow. Furthermore, this sets a legal precedent. Other judges, Judge Chutkan, Judge Merchan, are watching. This ruling gives them a framework. They can cite this decision. They can say, look, another federal judge has determined that fines are insufficient and that custody is a necessary threat. It creates a permission structure for the judiciary to be tougher. But we must also face the uncomfortable logistical nightmare that lies beneath the surface of this threat, the constitutional paradox. While the judge's threat of incarceration is legally sound, it opens a Pandora's box of practical realities that no civics textbook ever prepared us for. We need to talk about what custody actually looks like for a man who is legally entitled to 24-hour armed protection by the Secret Service. This isn't just about a jail cell. It is about a collision between two arms of the executive branch. The U.S. Marshal Service charged with detaining prisoners, and the Secret Service charged with protecting the life of the former president at all costs. If the judge were to follow through on her threat, we would witness a surreal logistical negotiation. You cannot simply put Donald Trump in a general population holding cell. The Secret Service would legally be required to be in the cell with him, or at least in the immediate vicinity, creating a bizarre scenario where federal agents are effectively imprisoned alongside their protectee. Experts suggest that jail in this context would likely mean a specialized, isolated facility, perhaps a converted barracks on a military base or a secure safe house, stripped of luxury but fortified against the outside world. This creates a gilded cage dilemma. If the conditions are too comfortable, the public will see it as a farce, proof that the wealthy play by different rules. If the conditions are too harsh, it fuels the political firestorm that he is a political prisoner. And consider the image that would be beamed around the world. The United States, the beacon of democracy, incarcerating its leading opposition candidate. To some, it would be the ultimate proof of the rule of law working, that no man is king. To others, it would look uncomfortably like the very authoritarian regimes we criticize abroad. Furthermore, we must consider the silent victims in this chaos, the jury pool. Every time this drama escalates, every time a witness is named or a threat is made, the pool of impartial jurors shrinks. The judge's explosion wasn't just about her authority. It was a desperate attempt to salvage the possibility of a fair trial. How do you find 12 citizens who can look at the facts objectively when the defendant is actively warring with the court itself? By poisoning the well of public opinion, the strategy threatens to make a fair verdict impossible, potentially leading to a mistrial, which might be the goal all along. This logistical and societal friction is why the nuclear option has been avoided for so long. It is not just about the law, it is about the fabric of the nation. The judge knows that executing this order would be the ultimate stress test for the American experiment. It forces the Secret Service, the Marshals, the Bureau of Prisons, and the courts to dance on the head of a pin, all while the world watches to see if they stumble. And this brings us to the most cynical, yet strategically complex aspect of this entire saga, the martyrdom strategy. In any standard legal defense, the goal is simple: minimize punishment. You stay quiet, you comply, you try to make the judge view you favorably. But we must recognize that we are not watching a standard legal defense. We are watching a political campaign that has effectively annexed the courtroom as its primary stage. There is a perverse incentive structure at play here that turns traditional legal logic on its head. For the vast majority of defendants, a threat of jail is a terrifying deterrent that ensures immediate compliance. But for Donald Trump, there's a very real, very dark calculation being made by his inner circle. They are asking themselves a question that sounds insane in any other context. Is getting thrown in jail actually the best thing that could happen to the campaign? Consider the mechanics of his response. Within minutes of the judge's ruling, fundraising emails were almost certainly hitting inboxes across America. The message is always the same. The deep state is trying to silence me. They want to put your favorite president in a cage because he fights for you. The narrative writes itself. Every fine, every gag order, every contempt finding is immediately weaponized into a badge of honor. It becomes proof that he is the ultimate outsider fighting a corrupt system. This creates a devastating trap for the judge. If she sanctions him lightly, he mocks the system, pays the fine, and proves he is untouchable. If she sanctions him heavily, like actually revoking his bail and sending him to jail, she risks turning him into a political martyr of historic proportions in the eyes of his supporters. He knows this. He is counting on it. He is effectively daring the court to make him a legend. This strategy of defiance as marketing does something even more dangerous than violating a protective order. It normalizes the delegitimization of our institutions. When a leader openly treats a court order as a partisan attack rather than a legal obligation, it invites millions of citizens to view the law as subjective. It suggests that laws are only valid if you agree with the judge who issued them. It erodes the social contract that says we all play by the same rules, win or lose. We are witnessing the collision of two distinct realities. In the reality of the courtroom, facts matter, statutes matter, and the rules of evidence apply. In the reality of the campaign trail, only the narrative matters. Trump is betting that the narrative is stronger than the law. He is betting that if he can convince enough voters that the judge is the villain, the legal outcome won't matter. This leaves the judge with an agonizing choice. She must enforce the law to protect the integrity of her court, but she knows that by doing so, she may be handing the defendant the very political ammunition he craves. It is a high-stakes game where the rule of law is the board and the stability of the republic are the pieces. The question is no longer just, will he violate the order? It is, does he want to be punished? And if the answer is yes, how does a justice system designed to deter crime handle a defendant who sees punishment as a promotion? If you're finding this breakdown helpful and want to stay ahead of these unprecedented legal events, please take a moment to hit the like button and subscribe to the channel. Your support helps us continue to bring you these deep dive analyses. Friends, as we reach the end of this analysis, we are left with the profound gravity of what lies ahead. The legal system is currently engaged in a high-stakes stress test. We are testing whether the rules written on parchment centuries ago can still constrain a man with the resources and reach of a modern media tycoon and former president. If Trump had continued violating orders without meaningful consequences, it would have sent a devastating message that judges are powerless to control defendants who have enough public support. It would have proven that there are indeed two systems of justice, one for the rich and powerful and one for everyone else. This ruling pushes back against that notion. It reasserts the uncomfortable but necessary truth that court orders mean something. It says that the dignity of the court and the safety of witnesses are more important than a candidate's desire to post on social media. However, the story is not over. Hours after the hearing, Trump posted on Truth Social again. He didn't violate the protective order, but he came right up to the line, complaining about being silenced. He is testing the boundaries again. He is seeing if the judge is bluffing. We are now in a game of brinkmanship. Will Trump actually comply now that jail is on the table? Or will his instinct to fight, to dominate, to never back down, force him to cross the line one more time? And if he does, will the judge follow through? The nation holds its breath, because if she does, if a former president is taken into custody for contempt of court, we enter uncharted territory. But if she doesn't, and he violates the order again with impunity, then we have lost something precious, the assurance that in America, no man is above the law. Thank you for your time and attention to this critical matter. It is through understanding these complex events that we, the people, can stay vigilant in the defense of our republic.